A very good evening, everyone. Our guest of honor, the AD of Housing Finance Bank, and all the other protocol observed. The condominium property law, which is fairly new in Uganda, I would like to appreciate and congratulate Frankina upon today. It is not easy for a lady to break through the property industry. And that is the reason why I thought it visionary to start the property network of women in Uganda. I'll just give a small example. Most of us are always on site. Most of people who are in the profession of the property network, especially the ladies, imagine this person maybe like a QS, I'll call them a quantity surveyor. They come on the site and they have come to audit, if I could call it, labor and materials on a site, and they're auditing men. They go through hell. So Frankina, for you to break through today, and we have gentlemen in the house who are in the property industry, a round of applause to you. I'll go straight to what I'm expected to break down today, and this is what Frankina's book is talking about. She has tried to break it down, all about the property as far as it is the condominium property. I'm not going to go through it because we have the books. I hope at least someone tried to read maybe the preamble or the first and second pages and you know something about it. I don't think there is anyone in the house who is here and they don't know what a condominium is. In case you're there, kindly just read the first page and you're going to know what a condominium property is. This is a very famous kind of housing in the first world. We could mention Europe, the United States, and it is known for one thing. It is known for organized communities. Call it curated. These are communities that must have a direction. It's not a matter of building, but there must be a direction. And that's why I think Uganda felt it prudent to come up with the Condominium Act of 2001. That is why I said it's a fairly new law. We do not know very many silent features that our property owner of the condominium or our property developer of the condominium is supposed to know. But I'm going to just, I hope everyone has read what the condominium housing is. Now, in a few words, when we talk about condominium housing legally, we mean any property as long as it is separately owned by an individual and with shared amenities in the same complex. That is simply what a condominium housing is. And that is why it calls for organization. Because if you do not separate and you tell me that this is my unit 1, you are going to pass here when you're going to your unit, then there is no organization in the estate. That's why the European man came up with this concept. It must be organized. And that is why even when you go in the rules and regulations of the Act, they urge developers, please make sure that there are boundaries in this property. However, I'm not sure whether all Ugandan developers are doing this. I don't know whether we have planning authority people. Frankina, I should have brought them here. They should be telling us what is supposed to be done. That is one of the major things we should know about the properties. We rush to amenities, we rush to everything, but we miss out the legalities. Is this property having its boundaries? Noted that this is one unit, it's facing this side, and that is what it is. Because if I'm going to own it individually, I should be able to know it. In Europe and US, this, even if we talk about Asia, by the way, it's one of the also most common condominium setups. Now, you find that these condominiums, at the end of the day, regardless of the organization and everything, they are majorly in cities. Coming back to Uganda or relating Uganda to the globe, we no longer have Uganda of one Kampala for a city. We have 1 million cities. That means I expect whoever is thinking about being a housing developer or whoever is already a housing developer to at least spread your wings, get out of Kampala. We are getting suffocated. Go to Arua, go to Gulu. On a busy night, you can be in Arua and you don't have anywhere to sleep. What are we doing in Kampala? Mr. Hydre, thank you so much for supporting Frankina, but get out of Kampala, spread your wings and take this good work out there because it's the kind of organization that we need, since it is the only option we have to break it down as far as the housing deficit is concerned. I'm now going to take us into the real legalities. Condo owner or developer should look out for. One, individual ownership. That is as far as the act is concerned. Like I mentioned, in as far as organization and separation of boundaries is concerned, it must be individually owned. By individual ownership, I do not mean that I, Viola, I'm going to have one unit because I'm an individual, and then the MC is going to have another one. No. By individual ownership, I mean each unit must have a title. I'm going to give an example. You will not have two semi-detached houses, and then they have one title, and then you're calling them condominiums. No, they must be separated. Each unit individually owned. That's what we mean by individual ownership. With that, then you are at least setting in the legalities. And then number two, the title deed acquisition. I don't know of anywhere where we have a Chibanja condo. Do you know of anything like that? No. There must be title deed acquisition. If you have a developer and they're telling you they have a Chibanja and come and buy a condo, please run for your life. At least we are aware of the, in case you're not aware, we have different ownerships of property. We have the customary, we have the lease, the freehold, and the private milo title. Now, customary is also not supposed to own a condo. It's not supposed to have a condo developed on it. Why? Because it does not have titles recognized by the government of Uganda. And then number three, like I mentioned, separate ownership, clearly stated, and built boundaries. And this is very, very clear in the 2012 regulations, because it is the third legality that is highlighted, and I talked about it when I was trying to explain what a condo housing is. We must make sure that there are separate boundaries of each unit. How? Because if we don't have it, we shall not differentiate between the unit and the common areas. So everything must have boundaries. If it's parking, this is parking. Everything. On the site plan, you're supposed to make sure that you lay everything in an organized manner for someone who is willing to buy to know what they are buying. Number four is the process of planning authority and condo titling. Now, in the house, we have housing developers, and we could be having someone who's thinking of, hey, every time they talk about condo titling, you're like, what is this thing? I'm on top of someone. How do I have a title if I'm sitting on top of someone? Because ideally, condos are not only, by the way, apartments. They could be bungalows, they could be everything, but what do you mean titles? We are on the same land. What do you mean I'm going to have a condo title? So I'm going to take us through briefly. It's going to be a story. I'm going to take us through the titling process, because someone could be thinking it's something so difficult to do, but it's a very, very, very simple thing to do. However, for the condo title in definition or by law, it is simply that title which is allocating that unit ownership by defining its number, its unit number, by defining its size. And then on this note, Frankina, thank you so much. I have always wanted a platform where I'm going to say this, and I'm going to say it. Housing developers in Uganda, stop lying to us. Stop selling to us wrong sizes. Go by what the law says. The law says you should put both sizes. The total area, or what we could call the built-up area, and then the unit area. By unit area, I mean the inside of the house, without even the balcony. Like the inside, and then the outside. But you find us having flyers on the market space, and we're saying, hey, we are selling to you 100 square meters. Then when you go on ground, they are even not 90. Let us do the right thing. Let us follow legalities. If we have anyone from the planning authorities, stop passing these condominium numbers. If you have not gone on ground, ideally and by law, if we follow the act, we are not supposed to have this condo number without sending an officer from the planning authority and the committee of housing. I saw some people here, the committee of housing in charge of condominium, come on ground to come and confirm. So dear developers, dear home buyers, willing home buyers, find out these things. Make sure that what you are buying is what is on ground. Because at the end of the day, we are trying to fight a housing deficit. How are we going to fight a housing deficit if we are not even giving the right acreage? Because ideally, if we go by UBO statistics, it is supposed to be 5 heads per unit of a condominium. Now, if we can't provide a unit which can carry at least 5 heads, then what are we doing as far as the housing deficit is concerned? Now, I'm going to take us through or run us through very fast in the process. Now, if you're a condominium developer or someone willing to know what you need to do with this titling, you need to go through these offices. You need to make sure that you approach the committee of the condominium at the Ministry of Housing. Then you need to make sure that from there, you are trying to convert this property into a condominium. They need to take you through all these things I've taken you through. And you need to be aware of them. The moment they pass them, hey, it's okay, there are separate boundaries, there's enough parking space, and so on. Then you are supposed to approach the planning authority of your area of jurisdiction. For example, if it is Fakradin properties in Kasangati, you go to Kasangati Municipal Council. If it is a particular developer in Mengo, you go to KCCA. Now, from that, they are supposed to relate to what your original drawing or intention, if I could call it, that is the structures and architectures. They're supposed to go through them, and they're like, you intended to build this. The committee at the housing ministry is saying, we go ahead and give you a condominium number. Is this what you had given to us for approval? The moment they are okay with that, then they will okay you to go to the registry of the zonal office of the district of your jurisdiction still. For example, I use an example of Kasangati. Then you'll be able to go to Wakiso district, MZO, and then you are going to process these titles. On that note, I want us to note one thing. This is when we have the separation that I've been talking about. Now, we had this mother title, whereby Fakradin Properties obtained a particular land, let's say 5 acres in Kasangati, and they are willing to provide very many units to Ugandans, where what we're talking about, the condo title, that condo unit, allocating your unit and ownership. Now, the moment they get there, at the district, that is when we have these titles subdivided into those number of houses. Assume Fakradin wanted to provide, let's say, 5,000 condo units. That is when they're going to say, okay, bring that mother title, and according to all these planning authorities, how they have agreed with you, dear housing developer, we are now going to break it down. We are going to break it down for you, and every person is going to own a condo title. That is what you already see on the flyers. Please buy unit 1, unit 2. That is the basis of that. Unless you have that, by the Condominium Act, you are not supposed to start selling your title, your project. Dear housing developers, you are going to sell a project and you get there and they bounce the submissions. What are you going to do? First, go through the process, have your condominium titles, because at the end of the day, if I'm going to come to buy from you, I should be buying a legally binding property. I should be buying a good title of the property. I should be buying a valuable property. Now, how is it going to be valuable if it is not yet converted into a condominium? If you're a home buyer and you're going to go to a property developer, kindly ask, do due diligence. Tell them, what unit am I buying? What condominium number is it? And then let's have it in place. And the reason why I'm saying this is, it's because the moment you are buying this condominium plan, which is already approved, that is what the developer is supposed to make sure that they put in place. And that is why when the planning authorities are supposed to come on ground and they're doing their checks and balances as far as the construction is concerned, they're supposed to compare with this condominium plan vis-a-vis the architectures and the structures and then what is on ground. So tomorrow when you come up with any issues or disputes with a developer in court, court is not going to listen to you because you did not take due diligence. You entered into something blindly. What do you want court to do for you? Approach a lawyer and they take you through. You should make sure that you take due diligence before you risk your monies. into any development. I'm not saying we have scams on the market space. I haven't heard of any, but I'm being realistic with what is supposed to be done. Now, that is it about the titling. And that was my number 5. Number 6, there is what we call a condominium agreement vis-a-vis the management rules. These are some of the features which you, especially a home buyer and developer, should pay attention to. I'm going to challenge housing developers. I'm sorry I'm using an example for Accredited Properties. For all reasons, Hydri, Mr. Hydri, you'll forgive me. We have Accredited Properties, and they have someone who has approached them to buy a condo from them. Now, ideally, the developer is going to give you a draft of a condominium sales agreement. I'm going to call it CSA for purposes of not, saying the whole word. Now, when the developer is going to send you this CSA, you as the person who is willing to buy this property, do not stop at that agreement. We rush to this agreement. The only thing in our head is how much is the condominium? How much is what period of the payment plan? And we stop at that. And then tomorrow, we forget that we are going to be in a space of shared amenities. Now, dear developers, this is our role. This is what the law requires us to do. Kindly share the condominium sales agreement as well as the management rules. And make sure that before you even give the offer letter to someone who's willing to buy, make sure that they have signed those management rules. Why? Because it is binding them to the concept of condominium legally. I don't know how many housing developers are doing that. I know Hydri does it. I don't know those who are not doing it. Please go. Someone listening in, someone who can pass on this information, please, let's make sure that we address the future at the time of purchase, because we avoid the future crisis by doing that. Otherwise, I have had cases where I have gone to court over management fees, and before me, the defaulter is a judge, God forbid. And they're saying, I don't know this, what are you talking about, this management thing? I paid my money, you gave me my title. What do you want from me? These are law implementers. But then it's a fairly new law. So it is okay for us to learn these things. But it starts with a developer. If we inform the people, people will appreciate the concept legally, and we shall not have disputes in courts of law. Not only on management, but in very many other things that the management rules are put forward. For example, if we had a change, if we have bought this property, this is in project management, they call it the control procedure. Imagine all this, everyone in here, we have a unit each at Mayfair Visitors, a project of Accredited Properties. Now, when everyone has a unit there, we realize that we want to make a change on this property. Does the law allow us to go ahead and make changes? Because they already passed a plan. But we realize we need to do something. Maybe we need to let go of an entire floor. Maybe we need to add something. But that is structure. How do we go about it? Now, by project management rules, also which apply in the Condominium Act, as owners, everyone in this room, we are supposed to come together and get the original plan from the developer and resubmit to the planning authorities with our changes that we have agreed upon. And if the planning authorities, they find it legal and binding, then they're going to tell us, please go ahead and have these changes. So you should not think that going in this condominium setup, you are a prisoner forever. No, we can come together. The law is very flexible. We can come together and have these properties changed to the setup, because what the vision of the developer was could be different from us. And we need to live in a place which you're comfortable with. So the law is very flexible on changes, even if they are structural. That takes me to defects. By law, there is what we call the defects liability period, or what we call the de facto period. Now, when the developer has put up such a property, you, a homeowner, and the developer should know this, that the law has provided a liability period of 12 months. You should make sure that you manage this property. You should make sure that you manage this property for 12 months before you pass it on to the owners. Why? I think that if the civil works people here, like civil engineers, they will tell us that you will not know how strong a house is or what you have done in a house, however smart you are, whatever materials you've used, if you have not used the house. So ideally, I think the law needed the developers to ensure that they are handing over a property which is functional and which does not have defects. We can never have construction without defects. I don't know if that is a different area. I'm talking about legalities. But as far as the law is concerned, let's make sure that we manage this property for all that period and hand it over to people. And the moment, the law is very clear, the moment you do not raise your defects in that period, also you don't expect a businessman who has put in their money for all this long to stay here for 100 years fixing defects. So I think that's why they gave it a limitation period, so that both parties can agree and then hand over the property. About if it is not the last point, as far as the salient features are concerned, we have what we call the corporation. Now, when I talk about the management rules, I should have talked about the corporation. I'm going to talk about it right now. When we have bought all this property, like the way we have agreed, in everyone in this room, we own an apartment, a condo apartment at Fakradin Properties. Now, we have gone through the changes, perhaps we've made changes, and the law is very okay with that. It is now time for us to be legally binding. What makes us binding is us to register what we call a corporation. That is what the law calls it. We have gone by the American law and we are calling it the Homeowners Association, but it's not an association, it's a corporation. Now, this corporation is supposed to be for all owners, and it is supposed to recognize each unit. Even if you are Viola and I own 20 units, the law is supposed to recognize 1, 2, 3, up to 20 units. And they are supposed to be registered on the mother title. Now, I'm going to thank and appreciate developers, the foreign ones on this land. We are not having any case of a developer registered that they have failed to hand over a title to owners. But we have 1 million cases of Ugandans, of indigenous developers who are not handing over the mother titles to owners. I don't know for what reasons. You find that you are buying a property, but this property is at Housing Finance Bank for a mortgage. I'm sure that Idi will agree with me and other bankers in the house that the mortgage deed does not agree with that. There is no way how you are going to pass on more interests on the same property to another party, yet already registered mine. Ideally, if your property is in the bank, you're not supposed to be selling these condos unless you have cleared the other encumbrance by the banking institution or whichever financier they are. Now, this corporation, we are supposed to all go to the developer upon 50% of owners and tell the developer, here we are legally binding to own this property. And it's supposed to be transferred from Fakradin Properties, the developer of 100 units, to the corporation of 100 units. And they're supposed to be put there, 1, 2, 3, like this, with all their details on that title. Something that Ugandans are not doing, and Hydra, I'm very sure you're not doing this, you're not helping because it's a new thing. After registering it with a register of documents, and now you know that the developer cannot use this property, then we are supposed to take it back to lands. There's an amendment of 2012 which is telling us to kindly go ahead and have a registry back at lands, because we have a constitution that binds the owners on how they are going to manage the property. You know, you're going to come in at 10, by 8 a.m. the gates will be open, that's all right. But as far as the ownership legally is concerned, it is, for example, if you had an encroachment on that property as the homeowners or as the corporation, you're not going to go to courts of law to sue anyone if the registry is not aware of this condominium property as owners, because the registry still knows Fakhreddin Properties. They don't know about when you form the corporation. So we realized that it was a loophole in the law. I think it was changed a few years ago, I remember under Registrar Aisha, that it has to go back to the registry. And we are not doing this. And the moment it is court time, that is when people are going to wake up. And they are throwing away their papers, they're dismissing them because they are not legally binding. So dear developers, any legal people here, please make sure that you guide the homeowners to further go ahead and register this property with, and re-register, actually, it's a re-registration with the district of registry as per the jurisdiction of that property. Those are the salient features that any buyer, any willing home buyer, any developer, any willing developer, someone willing to join the industry should be aware of. If we could all abide by them, we could not have disputes as far as condominiums are concerned. We can never exhaust all of them. Some come up and they're new, but at least if we know those ones, we could beat 90% of case disputes as far as the condos are concerned. Thank you so much.